Good evening, everyone, and thank you all for being here. I am Randy Barnett, and I am the faculty director of the Georgetown Center for the Constitution. As many of you know, the center is dedicated to advancing the people's understanding of originalism and history and the memories of those individuals who made our constitutional republic possible. Now, usually when people think about originalism, they think about Justice Scalia, and rightfully so. Justice Scalia valiantly dedicated his career to upholding our written Constitution. But he was not alone. Judge Laurence Silberman, who served on the U.S. Court of Appeals for the District of Circuit for 37 years, was a leader in originalist interpretation and exemplified an unwavering commitment to the Constitution. Through his meticulously researched opinions and keen analysis, Judge Silberman shaped our law and held everyone around him and the court interpreting his opinions after him to the highest standards and the rule of law. In fact, it is not an overstatement to say that Judge Silberman was, if not more influential than some members of the Supreme Court. I first met Larry. I know the day and exactly where it was when I first met Larry. It was in the fall of 2011, and it was on level P1 of the McDonough Hall, which is the faculty parking lot. This was shortly after the DC Circuit oral argument in the case of Seven Sky versus Holder, one of the constitutional challenges to the Affordable Care Act. Larry was on that panel, along with Harry Edwards and now Justice Brett Kavanaugh. I had attended that argument, as I had attended all the Court of Appeals arguments with all the challenges around the country. And afterwards, I wrote a blog post on the ballot conspiracy, contending that during his questioning of counsel, Larry had been overreading Wickard versus Filburn. Now, a few days after that post, I was walking towards my car in the evening as I was heading home. And who did I see walking towards me but Judge Laurence Silberman, who I had actually never met before. I had just seen him on the bench that day. And he was on his way to teach an evening class as a visiting professor at Georgetown Law. Now, I just want to stress, he was a visiting professor. He was not an adjunct. Because if you ever said anything, if you ever mistakenly referred to him as an adjunct, he would correct you. In fact, he would preemptively correct you before you even made that mistake. As we passed in the garage, I said, "Hello, Judge," and introduced myself. I mean, discussing the pending case with him in that parking lot was the last thing in the world I intended to do. But he being who he was, he insisted on engaging me in an intense discussion in the parking lot ensued, in which he insisted on the complete lack of any validity of our argument due to Wickard versus Filburn. Now, I started to reply to this, and he interrupted me. He says, "I read your blog post, and I'm not persuaded." So that was pretty much the end of my argument right there. He'd read it, it was over. He'd read the briefs. The day that the panel decision was announced, and the panel decision basically upheld the Affordable Care Act, that happened to be the same day as the Federalist Society's Lawyers Convention at the Marriott Wardman Hotel. When the festivities ended, we found ourselves, Larry and I found ourselves walking together out of the banquet room, up some stairs. And as I saw him, as I spotted him, I said, because the opinion had just been come out that morning, I said, "How does it feel to be the left's favorite conservative judge for having upheld Obamacare?" And I'll never forget his reaction, which was wordless, but just motion. He just went like this. But Larry got the last laugh, as he usually did. At another reception of some kind, I don't remember what it was, we were standing with a small group of lawyers and law students, and there he publicly challenged me to bet on the outcome of the case. Now, I am not a betting man, and I don't bet on things like that, but I could hardly back down from the challenge to put my money where my mouth is. And so we bet a dinner. Now, after the case was decided adversely, I reached out to him to settle our bet. I wrote the following in the email: even though a majority accepted my interpretation of the Constitution and case law and rejected yours, I wrote, I think I owe you a dinner. His response, which was typical Larry, was, you are an honorable man for whom I have no sympathy. But in the end, of course, I was the winner because it provided a wonderful opportunity for my wife, Beth, and me to meet Tricia, his lovely wife, who I'm very pleased to say has joined us here tonight, as the four of us dined at a French restaurant in Georgetown. And I'm so pleased that you were able to join us, Tricia, as we pay tribute to Larry. Just last year, I invited Larry to be our keynote speaker at the Center for the Constitution's annual Originalism for Judges seminar in Sarasota. Larry replied, quote, I'm flattered and I would love to speak at your conference, but I am taking Tricia to England on the Queen Mary for her birthday, and we will be away for your conference. I replied, well, that's no excuse. But oh well, it sounds delightful and I'll be back. Unfortunately, it's now not going to happen. But at next year's seminar, I promise that we will all drink a toast to Larry and his absence. We are greatly shocked and saddened by his sudden passing. He was the kind of larger-than-life personality who seems immortal. But his memory and his legacy will not be lost. I am grateful to our esteemed speakers, all former Judge Silberman clerks who have kindly agreed to share their own memories of the judge, discuss his opinions with us, and give us a peek into the inner working of Judge Silberman's chambers, with the hope that we can take a little bit of his genius and with us and apply it to our own work. But before we get to our speakers, I want to welcome my dear friend, the Dean of Georgetown Law, Dean William Traynor, without whom the Georgetown Center for the Constitution would not exist, to say a few words. Bill?
Well, it's wonderful to see you all here, and thank you very much for that warm introduction, Randy and Tricia. It's so fabulous to see you here as we're paying honor to the judge. He really was. And I was thinking about, what I would say. First of all, he was a great man. He was an extraordinary judge, as Randy has said. A remarkable career in public service, even if he never had been on the Court of Appeals, as an ambassador, as Deputy Attorney General, somebody of extraordinary integrity and intelligence, and really a role model, for, I think, everyone who knew him. Randy talked about the first time he saw the judge. I remember the first time I saw the judge, which was not for me a happy day. So I worked on the Rand-Contra special prosecution of Oliver North, and so the argument. So Oliver North had been 3 counts convicted, and it was before the D.C. Circuit. And Jerry Lynch, who's now on the Second Circuit, who I have to say, I always thought was the smartest lawyer I've ever worked with. I'm actually just looking at Steve. I've worked with anybody else in this room. So, but just absolutely brilliant Columbia law professor, Supreme Court clerk, really amazing. And we worked forever on his argument. And the big question for the D.C. Circuit was the scope of the Supreme Court decision in Castigar, which was a decision about when somebody had given immunized testimony. What was its consequences for subsequent prosecution? So it was the big issue in the North case. We spent years preparing for it. And so, Jerry Lynch, absolutely brilliant, gets ready. And then the first questions are from Judge Silberman. And so he says, Professor Lynch said, I've heard your argument about Castigar. Doesn't this follow And Jerry Lynch said, yes. And then he said, and then doesn't that follow? Jerry Lynch said, yes. And he said, and then doesn't this follow? And Jerry Lynch said, that's, and doesn't this follow? And Jerry Lynch said, yes. And then he said, so isn't your argument totally wrong? And I have to say, I remember thinking, he is brilliant. And I was actually talking to Judge Lynch last month, and he still remembers that, not with affection. But, it really, for me, that moment kind of stood out that the judge was really a lawyer's lawyer, extraordinarily brilliant, extraordinarily skilled in legal analysis. And we were so fortunate to have him as a teacher for our students. So, the theme of today is really the judge as mentor. And I'm going to read some of his student evaluations, which were fabulous, before I introduce the justice. But before that, I just also want to say, what a great friend he was. When I became dean, he was one of the first people who reached out to me. We had lunch regularly. Tricia, you and the judge came to our house. You kindly invited us to yours. And he was such a warm, funny person and such a great friend. And so it was a joy to have him in our community, and it was a joy to know him. So, we will all miss him, and he was in every way a giant. So some of the teaching evaluations, he was a great teacher. It's the reason, I think the two things that, he would take affront of, in my experience, were referring to him as an adjunct. He did not receive that well. The other, which he was actually even more forceful in opposition to, was, I believe that when we had our first lunch, he said early in his career, he had been a Rockefeller Republican. And every time I would bring that up with him and afterwards, he absolutely objected. He was never a Rockefeller Republican. So for those of you who are kind of younger, a Rockefeller Republican was the wing of the Republican Party, roughly like AOC. So, so he was very forceful when I would say he was a Rockefeller Republican, and he would deny that. So some of the teaching evaluations. Judge Silberman is the CAPS expert on this stuff. It was a privilege to be his student. He made a lot of people uncomfortable by demanding correct answers from them and interrupting their incorrect answers. I am glad he did so. We are better off not hearing the incorrect answers. I like a tough professor. Next one. Judge Silberman is fantastic. I'm very lucky to have him as a professor. Next one. I really loved you. This is written to the judge. I really loved you as a professor. The topic is very difficult. I specifically made sure my course load would include you, and I am very happy I chose to do so. I love that Judge Silberman is able to incorporate real-life experience as a judge on the DC circuit into his lessons. What an amazing way to learn. Another student. The way Judge Silberman teaches is the way all law professors should teach. It's the classic Socratic method you imagine law school should be. The discussion becomes intense and really derives into the minutia of the doctrine. I love his wit. And the final one, this was one of my favorite courses in law school, if not my favorite. Judge Silberman supplies an analytic and intellectually curious lens for the material, which is not only interesting, but valuable. His teaching has helped shape the way I hope to conduct legal analysis throughout my career, and I now both enjoy administrative law and want to work in a legal field that touches upon it. And that really captures it. I mean, he was a model teacher. He was brilliant in the classroom. He was so excited about his students. He would come up to me and he said, I'd meet him in the hall and he'd say, I want to tell you about what one of my students said today in class. He loved being a teacher and he loved his students. And from evaluations like this, you get a sense of, how fortunate they consider themselves to be because they had Judge Silberman and the way in which for so many he shaped their career. We were so lucky to have him. And just as he was a mentor to so many of our students, he was a mentor to his clerks. So that's going to be the focus of the rest of the program. We're going to hear from some of the judges' former clerks, and we're going to begin with the justice. I now have the great honor of introducing one of the members of Judge Silberman's remarkable legacy, someone of whom I know he was immensely proud. Justice Amy Coney Barrett joined the United States Supreme Court in 2020, a recognition of her impressive legal career up to that point. Before joining the court, Justice Barrett served as a judge on the United States Court of Appeals for the Seventh Circuit, and before that was a professor at another great Catholic law school, Notre Dame. But before this legal career really began, Justice Barrett, who graduated first in her class at Notre Dame, was a law clerk to Justice Scalia and the man we are here to honor tonight, Judge Laurence Silberman. So please join me in welcoming somebody who the judge was so proud of and who's had an extraordinary career, Justice Amy Coney Barrett.
Thank you, Dean Traynor. So exactly 25 years ago this year, I walked into Judge Silberman's chambers to start my clerkship with him. And I can say that I would be stunned if I was alone among his law clerks and being in total awe of all of his accomplishments. You know, the accolades that he has been given since he unexpectedly died have highlighted so many of those, and Dean Traynor mentioned some. I mean, he was a high-ranking official in the Department of Justice, high-ranking in the Department of Labor, ambassador to Yugoslavia. He was co-chair of the Rob Silberman or Silberman-Robb Commission. He received the Presidential Medal of Freedom. And of course, we wouldn't be here tonight if he hadn't taught, which he loved, despite the fact that it added to his load if he hadn't served for nearly 30 years as a teacher. The Wall Street Journal called Judge Silberman one of the all-time giants of the legal bench, and they're right. But for the moment, I'm not going to talk about his professional accomplishments. Borrowing from David Brooks, I'm going to talk about his eulogy virtues rather than his resume virtues. After all, that's what's important. The man who Larry Silberman was, not what he did. His career, seen through this lens, gave him a multitude of opportunities to show what he was made of. So I just have a brief time to speak. So this isn't going to be a comprehensive list of all of the wonderful traits of Larry Silberman. I'm just going to hit a few of the highlights. First is honor. The judge often spoke about the importance of honor, and that's a trait that he had in spades. A few examples. The judge was fired as Undersecretary of Labor for 2 offenses: refusing to fix cases in the Labor Department for Chuck Colson, and for hiring a Black regional director over the objection of the White House, the Nixon White House. On another occasion, the judge turned down a job in the Nixon administration because it was conditioned on what he thought would be disloyalty to a senior official that he would be serving in his department. Another one that's well known. As acting Attorney General, it fell to him to review the notorious Hoover files, dossiers of dirt that Hoover compiled on public figures for purposes of blackmail. He described it as a stomach-turning task, and he was utterly appalled by the abuse of power that confronted him in those files. That was juicy stuff, and it weighed heavily on him, and it would have been tempting to share it if only to get it off of his chest. But he did not betray his professional duty of confidentiality. He took the secrets of what he found in those files to the grave. Another character trait, guts. It's kind of an understatement to say that the judge was willing to express an unpopular opinion. He was doing that up until the very end. Just a month before he died, the judge celebrated Constitution Day at Dartmouth, with the speech that criticized the very en vogue practice on college campuses of suppressing controversial speech. Another example, early in his tenure on the DC Circuit, a number of cases had been en banc because there was a new influx of judges, primarily textualists and originalists, that shared Judge Silberman's jurisprudential philosophy. And those judges had voted to take cases en banc to get it right, to overrule panel decisions with which they disagreed. And one of Judge Silberman's colleagues criticized that, one who was more, I would say, took a more liberal view of the law than he did. And he was persuaded. And so he sent a memo de-en-banking 4 of the cases. And that came at personal cost. It ruptured his friendship with Robert Bork after that, but he thought it was the right thing to do, and it set a tone in the DC Circuit of respect for panels so that en bancs were rare. This third quality is one that I have trouble putting a name on. Some might call it bipartisanship, but that's not really a character trait. So I'm going to say it this way. Judge Silberman had the right mix of humility and confidence that enabled to work with and love those whose ideological commitments differed from his own. A man who lacked confidence in his positions might prefer to hunker down in an echo chamber for fear that he wouldn't be able to hack it if he got in a debate with someone who disagreed with him. That was not the judge. He relished an argument. And from clerk hiring to professional interactions, he welcomed a diversity of opinion. Indeed, in his friendships and all of his relationships, he welcomed that. I think maybe this is best exemplified by his funeral service, during which both Dick Cheney and Attorney General Merrick Garland spoke. And it was beautiful and moving to see that the judge's closest friends were chosen without regard to whether they shared his political or ideological beliefs. Indeed, that was true of love too. When he told me that he was marrying Trisha, he said, now she's a Democrat, but that won't get in the way. Would that we all had the same motto about political differences. Good judgment. Okay, now here I'm not talking about his body of judicial work. I'm talking about his ability to judge character. He was very capable of sizing people up, and he could do it quickly. It took him one dance with Ricky, his first wife, to decide that he would marry her, and they were happily married to his death. And he asked Trisha to marry him on the second date. Their marriage, too, lasted happily until his death. He could judge people, friends, too. He met Justice Scalia when he interviewed him for a job at Justice, and he instantly had, as he said, such admiration and affection for him that he offered him the job, stopped looking, and began a lifelong friendship with Justice Scalia. That leads me to loyalty. As I know that Paul and Sarah and Carl and all of the judge's other clerks would attest, the judge was one of the most loyal men that I know. This isn't a town in which loyalty is necessarily prized, or at least it might be observed in the breach. But the judge never wavered in fidelity to his clerks and to his friends. He was a patriot. He was a man of integrity and strength. He could be fierce, as the lawyers who appeared before him can attest, but he was affectionate and funny, and he won the undying loyalty of his clerks. Speaking personally, I really appreciated having the judge, who was fierce but also loyal, sitting behind me at my 7th Circuit confirmation hearing. My hearings for the Supreme Court were closed because of COVID, so he couldn't be there then, or I'm sure he would have been. During the 7th Circuit hearing, I mean, that was my first opportunity to be a political punching bag. You know, I left and I walked out in the hall, and I was pretty shell-shocked by the entire experience. But Judge Silberman was exhilarated. He loved it. I mean, he just, that kind of a thing just got his adrenaline going, and he wanted to kind of go over like blow by blow. He was so excited. I just needed a moment to take my breath. But he was a cheerleader. So he thought it had gone well, despite the fact that, I felt like I'd been completely beaten up, and, he was there to support me and give me a boost. I loved him and I really miss him, as I know so many of his friends and his clerks and his family do. So I will turn it over to the panel to talk about his mentorship further. Thank you.
Thank you so much, Justice Barrett, for coming here and doing this and for those wonderful words. We really appreciate it. The panelists now can come on up, take their seats. I'll do a general introduction, and then I'll be asking the panel questions. I want to welcome our esteemed panel, Judge Carl Nichols of the U.S. District Court for the District of Columbia, Paul Clement, former Solicitor General, Sarah Harris, a partner at Williams & Connolly. So let me give a brief bio of each one, but they're all three so accomplished that this has to be highly truncated. I'm sure they would prefer that themselves. First, we have Judge Carl Nichols. Judge Nichols was appointed to the DC Circuit in 2019, before which he was a partner at Wilmer Hale, a principal deputy associate attorney general for the Department of Justice's Civil Division, and a partner at Boyce Schiller. Unsurprisingly, given that he graduated with high honors from the University of Chicago Law School, Judge Nichols clerked for Justice Clarence Thomas, and most importantly, for tonight's purposes, he served as law clerk to Judge Silberman from 1996 to 1997. Welcome. Next, we have Paul Clement. Paul served as the 43rd Solicitor General of the United States from 2005 to 2008, and before that, as the acting Solicitor General and Principal Deputy Solicitor General. With just a little bit of practice in appellate advocacy, that is, Paul has argued over 100 cases before the United States Supreme Court. Paul is now a named partner at his firm, Clement and Murphy, where he continues his high stakes appellate advocacy, partnering with my former student here at Georgetown, Aaron Murphy. Paul received firsthand training in premier constitutional advocacy through his clerkships for the late Antonin Scalia, and from 1992 to 1993. And at those years, he clerked for Judge Silberman. Paul and I argued against each other in the Gonzalez versus Raich case, which was my one and only appearance before the court. And then a few years later, we were on the same side in the challenge to the Affordable Care Act, which was nice to be on the same side. Last but not least is Sarah Harris. Sarah is a partner at Williams & Connolly, where she has argued 3 cases before the Supreme Court, and she has won 3 cases before the Supreme Court. As someone with a win-loss record of 0-1, I am extra impressed by that stat. Sarah is recognized as a leader in appellate advocacy and truly an ever-rising star in the Supreme Court and appellate litigation. Before joining Williams & Connolly, Sarah served as a Deputy Assistant Attorney General at the DOJ's Office of Legal Counsel. She also clerked for Judge Sandra Lynch on the First Circuit, Justice Clarence Thomas, and then, of course, Judge Silberman from 2011 to 2012. Please join me in welcoming our panel. So jumping right in, I was hoping you could all share a little bit about how Judge Silberman approached his cases. Judge Nichols, let me start with you. Is there anything about the way Judge Silberman approached legal questions that you apply to your cases now, lessons that you learned from him?
Absolutely. Let me just first thank you for hosting this and for the law school for doing this. Judge Silberman loved teaching here. He loved the school, and I think it's terrific that you're doing this. As I was reflecting on this possible question, I think there are 3, and I learned a lot clerking for Judge Silberman. He was, as others have said, brilliant, and as learned a person of all things in the world, foreign policy, history, and the like. So clerkship was a learning experience every day. But the things that I learned that affect me most, I think, as a judge are, first, the thing he said to me on day 1 is, there's a right answer in every case. It may not be obvious, but the job is to figure out what the right answer is. There is a right answer. And that was consistent with point 2, which is very important to me, which is he had a very, very, very strong view of the line between policymaker, and judge. And in his view, we aren't policymakers. We decide legal questions. And he very much disavowed any idea that the judge is policymaker. And so in his view, the question always was, what's the right answer from a legal perspective? I know this sounds simple, but in practice, it can be difficult. But we are not policymakers. And the last thing I would say is, this is a smaller point, but it's one that was not so obvious to me in law school, and it's very obvious to me as a district court judge, and that is the importance of basically leaving parties to litigate their cases, to not making arguments that the parties haven't raised, to not inventing questions that the parties have decided not to present to you. Came up time and again in the DC circuit where a party perhaps would argue something, when I was clerking for him, I mean, that had not been argued below. Every week right now, my clerks and I, we have many cases, it would be very easy to reach out and look for a question that the parties haven't presented. And for Judge Silberman, it was very critical that the judge not essentially be an advocate. You know, he's deciding, or she is deciding cases and allowing litigants to do their jobs, presenting the claims they're going to. And if they're not going to present a particular claim for whatever reason, not reach out and decide something that hasn't been presented.
Thanks. Paul, how did your clerkship affect your view of cases, especially when you took on the responsibility of being Solicitor General?
Well, so Randy, I'll answer that in a second. I just also wanted to say, thanks for having this. The judge did love this law school. And I think that a night like tonight just shows why this is such a great law school, because we can talk about somebody like Judge Silberman, who walked down the street and taught students here year after year and gave them a unique insight, and have a justice of the Supreme Court walk down the other direction and be on campus. And I just don't think there's any school in the country that can give students these kind of experiences. So
And I can tell you never know who you'll run into in the parking lot.
You don't, apparently. And you got off easy, it sounds like. So in terms of the experience of working with Judge Silberman as his law clerk and sort of what that brought to my time in the Solicitor General's office, I'd say what was fascinating to clerk for Judge Silberman is he came to the bench, obviously, with all this incredible executive branch experience, including functionally running the Justice Department, because the Deputy Attorney General is kind of the chief operating officer of the department, and he had a very good working relationship with General Saxby. So he kind of understood how the department worked. He understood how the department liaisoned with other parts of the executive branch. And one of the great things as a young law clerk is, after the arguments, he would tell you exactly what he thought of the advocates in general, but the government advocates in particular. And when he would praise some of them, but not all of them, he would make clear when he thought that they were not being the right kind of government advocate, that they weren't actually faithfully representing the positions of the government, that they're kind of trying to answer one of his questions to get out of it, but not actually representing the long-term interests of the executive branch. And so, having kind of had that experience early on, when I was privileged to be in the Solicitor General's office, I would definitely hearken back to that. And it was, of course, fascinating because there were a couple of people I interacted with on a daily basis at the Justice Department that I had seen argue in front of Judge Silberman. And I knew exactly what he thought of it. And on one occasion, I even made a recommendation that one person argue a case in the DC Circuit instead of another, because I knew how the judge would perceive one advocate versus the other. So it really, and I felt like, and I think in the SG's office, but also in other instances, there was always this tendency to sort of think that Judge Silberman, or a miniature version of Judge Silberman, was like sitting right there, kind of looking over at your shoulder and making sure that you were doing the job in the right way. And, Carl mentioned, Judge Nichols mentioned that this kind of clear difference between policy and the law and the role judge versus policymaker, but also the role of a lawyer versus a policymaker within the executive branch. And that was also a lesson they just brought to bear on a daily basis in the Justice Department, that, we weren't supposed to kind of tweak the legal position because we didn't really love the policy position. And, I remember when I was Solicitor General, on occasion, when somebody was complaining about a reg or a rule and sort of suggesting that we didn't fully defend it, or we didn't take a appeal of an adverse decision because we didn't really like the policy. On one or two occasions, I sort of told somebody, I kind of wrote down the address of the policy department, whether it's the labor department or the health and human services, said, you can walk down the street, and if you can convince them that the rule's a bad idea and to withdraw the rule, that's great, because we got plenty of other cases. But until you can convince the people who promulgated this rule that they should withdraw the rule, we're going to defend it. And where did I get that? I got that from Laurence Silberman.
So Sarah, we've now heard from Judge and the influence Judge Silberman had on a judge and on the government attorney. As someone in private practice, how did your clerkship with Judge Silberman affect how you approach the job as a private practitioner?
So I'll start by, again, also thanking Georgetown in keeping with the trend of the panel, because I think it's impossible to clerk for Judge Silberman and not have a sort of imputed to you a love of Georgetown as well, and how much he enjoyed teaching the class. How he sort of affects how I view private practice and, litigating. I mean, Paul said it right. I think for me, the judge is sort of your default audience, the voice in your head. And so thinking about what would happen if you were questioned by the judge and submitted the brief that you're working on is a very valuable exercise. There's a famous story in which a litigant before the judge was questioned so vigorously by the judge that he apparently fainted, and the judge then performed CPR. So that gives you a sense, it's a frequent story in the Silberman clerk family that tells you better do a good job making sure you anticipate hard questions and are not inundated by them by surprise by the time you're up there. And I do try to live by that in doing briefs. And he also his writing style, I think, of being short, to the point, not necessary frills, saying just what is your line of analysis and trying to think through all the permutations is just a really valuable lesson in terms of being an advocate. And of course, then there's matters large and small. And another one is just don't use acronyms. He really, really hated acronyms. And to this day, I try to declare war on them.
One of Judge Silberman's most famous cases is his decision in re sealed case. There, the DC Circuit famously held that the Independent Counsel Act was unconstitutional. This is the case that eventually became Morrison v. Olson. Paul, even though Judge Silberman's opinion was eventually reversed by the court in Morrison v. Olson, you're on record as noting the importance and lasting impact of that decision. Do you think that Judge Silberman got it right? And if he did get it right, how did he get it right, where other people, including all but one members of the Supreme Court, got it wrong?
Yeah, so I always prefer to think that Judge Silberman in that case was affirmed 1-7. And I honestly think that the rest of Washington agrees with me then. I mean, yeah, it's Morrison v. Olson is still on the books. It hasn't been overruled. But I think in the kind of popular mind, the judgment and Congress letting the independent counsel statute expire has sort of vindicated the vision of Judge Silberman and Justice Scalia. And, as I tell my separation of powers class, I told them earlier today, I think one of the lessons of Washington and separation of powers is you can only really see clearly the right answer in a separation of powers case after both parties' political ox has been gored by a phenomenon, by a law, nationwide injunctions, call it whatever you want. When it happens the first time, and it's just kind of the Republicans getting beat up by an independent counsel, people on the other side say, this is fun. But when the worm turns and then you have a Democratic president subjected to an independent counsel and all the distractions of that, then people can see clearly that there really is a fundamental problem here. And Judge Silberman didn't need both parties' oxen to be gored to see the fundamental basic problem with putting prosecutorial power in the hands of somebody who is accountable directly to functionally no one. His experience in the executive branch, his experience in Washington, all of that practical experience was brought to bear in the majority opinion for the DC Circuit in Ray's sealed case. And of course, then when it got up to the court, it's no accident that Justice Scalia, who had gotten that job at the Justice Department because the judge and the justice hit it off so well, had also had the experience of being in the Justice Department. And I think, again, it's not really an accident. I mean, Chief Justice Rehnquist should have got that one right too, because he had been the head of OLC. But the jurists who had that serious, deep executive branch experience, to paraphrase Justice Scalia, saw that wolf as a wolf. And Judge Silberman saw it as a wolf even before Justice Scalia.
Judge Nichols, do you have any thoughts on Morrison v. Olson or the independent counsel law?
It was beaten out of me during my confirmation preparation that as a nominee to a lower court, I should never comment one way or the other on whether I like Supreme Court opinions, because there's a slippery slope. If I say I like a particular opinion, then you say, well, what about Roe versus Wade, or what about Dobbs? That was as a nominee. Obviously, I'm not a nominee anymore. I share Paul's view. One thing I did before this event was I reread that decision, which I'd read many times over the years. And what I will say is, again, agree with everything Paul said, but it really is, Judge Silberman's opinion is a tour de force in the following sense. He starts with the text, the appointments clause. He then proceeds through essentially, framing era historical information. He then brings to bear his executive branch experience and what happens and the understanding of how the Independent Counsel Act would work. And then, and this is one of the other things I would have said earlier about what I learned from him, is he, in the opinion, talks about the practical or logical consequences of the position on the other side. And that's one of the other things I learned from him, is when you're thinking about a position, either side or your own view, to really, really push to think about what is the logical consequence. It's a little bit what Dean Traynor was saying earlier about the argument that Judge Lynch did. He continued to push on what the thread, he pulled the thread. And so the opinion that Judge Silberman wrote was really, in my view, a tour de force in all of those ways. And the other thing I would say is I agree with Paul entirely that one thing I do try to do now, and it wasn't really something I learned from Judge Silberman specifically, is I try to think about cases as if the political parties were flipped. To me, I think that's a very important way of approaching cases. I had cases during the Trump administration, I have cases now where I think about the issue and then I say, well, wait a second. If the Biden administration were a Republican administration, how would I feel about it, and vice versa? And I think it's often a very good way of getting clarity in your own mind about whether you're being as principled and objective as you could be. And what's remarkable, again, is that in the independent counsel context, you didn't have that context yet having happened where we do now.
Sarah, let me ask you about Judge Silberman's thought process here. Now, he wrote his opinion. He persuaded one justice, Justice Scalia. When you were a clerk for him, did he write with the justices in mind? Was he writing to the Supreme Court justices to try to persuade them or appeal to them in the way he constructed his opinions?
I don't think so. I think he was writing just to fulfill his oath. I mean, and I think the way he probably, one way of thinking about it is he was writing what he thought was the right answer. And if the justices did not think it was the right answer, he still maintained it was the right answer.
Fair enough. So now let's move from in re seal cases. It was not the only time that Judge Silberman had a deep impact on a Supreme Court decision. His opinion in Parker versus District of Columbia essentially became the majority opinion in DC versus Heller, where the Supreme Court held that individuals have a constitutional right to keep and bear arms for reasons other than serving in a militia, for example, like in self-defense in the home. Now, there's some people who actually think that Judge Silberman's opinion, his lower court opinion, might have even been better than Justice Scalia's majority opinion for the court. And one of those persons might actually have been Judge Silberman himself. It's quite possible. I think that might be true. Now, this opinion, both his opinion and the opinion for the court, took a famously originalist approach to the Second Amendment, which in turn has resulted in vigorous originalist debates amongst the justices. We've gone from a situation where even Republican nominees didn't call themselves originalists to now when Democratic nominees essentially call themselves originalists. This is a huge difference. Sarah, let's start with you. The opinion came out in 2007, so this was a few years before your clerkship. What was Judge Silberman's judicial philosophy on constitutional questions, and how did that affect his view on cases like Heller?
I would say, I mean, originalist constrained by precedent, which is the nature of being an originalist, I think, as a Court of Appeals judge. And so Parker and in Ray Sealed case, I think were both remarkable because now I think everyone is an originalist or professes to be an originalist of some form. And it's easier to be an originalist because there's lots of discussions about how to be an originalist and how to look at the sources and, you know, which ones are hot right now and what you should be looking at. But Judge Silberman in both of those cases was an originalist before it was super duper trendy. And it was hard work, I think, in both of them, because especially in Parker, not a lot of work had been done on the Second Amendment. And a lot of it was sort of taking a step back saying, okay, like there's not a lot of precedent out here. What are the relevant sources and how do you synthesize them on a tremendously important question? And the same thing with In Ray Sealed case. I mean, again, I think before the appointments clause was a perennial feature of the Supreme Court docket, he was doing some pretty hard work looking at like sifting through sources that were not getting a lot of play in judicial opinions. And Seven Sky, which Randy, you've talked about as well, I think also illustrates the flip side of that approach, which is if the judge genuinely believed that a Supreme Court precedent constrained him, in that case, Rickard versus Filburn, that was what he respected. And he did genuinely think that. And I think that also illustrated that he was an originalist even when it hurt, which is, you know, you might not personally like the results you get out of it, but that was part of the deal.
Well, and along those lines, his opinion in Parker was all the more impressive because he was a senior judge at the time, which means he didn't have the full complement of 4 clerks to help him write that opinion. And so, Judge Nichols, how did Judge Silberman approach the research side of this when in cases involving detailed historical and textual analysis, given the limitations of the role of the judge?
I really don't know, to be honest. One of the things I did when Judge Silberman unexpectedly passed away was I went back and essentially refreshed my recollection about the cases that were decided when I clerked. Because none of them in my mind that I had remembered at least was a blockbuster constitutional question. And at least when I looked through those old cases, that my recollection seemed right to me. So in my year with Judge Silberman, we never had occasion to do the kind of hard sort of new constitutional thinking, whether originalist or otherwise. And frankly, I think it's really hard. It was, I'm sure, very hard for them at the time. And frankly, it would be very hard for me right now to do a truly originalist take on an issue that is pretty new. And as between those two cases, I actually think that the Heller case is probably more historical in a way than in Ray Sealed case, and was, as Sarah was saying, going over pretty new ground. And so I think it's a pretty remarkable achievement. Having said that, I don't know how they got it done, because I was never in chambers where we had to do it as a clerk. And I just know that today, as a, again, district court judge with just 3 clerks and with fewer resources and less devoted to the cases, I think it would be really, really hard to write an opinion like that.
Paul, what do you think it was about Judge Silberman's opinions that made them so enduring?
So I think it was a couple of things, but I do want to just echo one thing that Judge Nichols said, which is one of the great disciplines of Judge Silberman, and it reflects kind of his view of the right way to be a judge, was he didn't make a case any more interesting than it needed to be. I mean, he didn't, like in some case that really was a nothing burger, he would decide it as a nothing burger. If the parties had not briefed an issue that was substantially more interesting than the issue that they briefed, it would at most merit a footnote suggesting that maybe they should have briefed it. And so I honestly think in some respects, you know, some of these cases that came to him as blockbuster cases where the luck of the draw and his perception on the bench made him realize that the Second Amendment was not decided in the DC circuit, even though in his view, most of the other circuits had got it wrong long before. But he had this opportunity there and he decided this enduring opinion. But the reality is, you know, my firm belief is if the DC circuit in a Skelly Wright opinion 20 years earlier had blown that, he would have just applied the Skelly Wright opinion. And I don't think he even would have gone on for 100 pages in a concurrence. I just don't think that's how he conceived the judicial role. And so when you get to see him tackle one of these kind of great issues, I mean, it really is something special because you know this is somebody who is tackling that issue because it's squarely presented. And if the opinion goes back to the framing, it's because there wasn't a Supreme Court case or a prior DC Circuit case that decided the issue. Otherwise, he would have just applied. I mean, I think that there is a modesty and a judicial humility in the way that he approached the cases. And in a way, you might miss that if you only focused on kind of In re sealed case and Parker and a few of these other In re North, you know, a couple of these, you know, kind of really high profile cases, you might miss it. But there's a beauty in the humdrum FERC case that frankly, I did the same thing the judge did. You know, we didn't decide anything like hugely important, but you know, he decided them very well.
Can I just add one
Sure.
thing, which is, so when I reread the Heller case, it wasn't called Heller on the DC Circuit, there's actually a long section at the beginning about Article 3 standing because it was a pre-enforcement challenge to the DC law and only one of a bunch of plaintiffs had standing, and that was because Heller had applied, I think, for a license. I am 100% certain that if Heller had not applied for a license, that Judge Silberman would have held that there was no Article 3 standing for any of the plaintiffs and he would not have reached the merits. I am convinced that is true. He didn't reach out to decide that Heller had standing. He just thought he did. And he held that all the other plaintiffs did not have standing based on binding, you know, Court of Appeals, but also Supreme Court precedent. And so I agree entirely with Paul that he was very principled in deciding the case that was before him.
I want a question that kind of pursues that line of drawing a line and acting within the appropriate boundaries. President Bush asked Judge Silberman to co-chair the Commission on Intelligence Failures leading up to the Iraq War. And during that period, he essentially took a leave of absence from the court, stopping all his judicial work to avoid any separation of powers concerns. And he's likewise demanded a similar resolve from fellow judges and justices. Judge Nichols, can you tell, I mean, you've already sort of answered this question before we got there, but that was about his role as a judge. Something else, just about, and this is something that Justice Barrett has already mentioned in her comments about his character, about his ability to stay above board, above the politics and small p politics that sort of affects everything, especially in DC, given that he was here and physically present in DC.
So I would echo what Justice Barrett said and what others have said about his character. I've been fortunate enough, I worked at DOJ, overlapped with Paul a little bit back in the day. Been fortunate to work with a number of very talented, but also very principled people in my career. And Judge Silberman was the most principled. I mean, others were as principled, but the most principled person I've ever worked with. We talked about it with respect to government lawyers, all lawyers in front of us. We talked about it over lunch when I was no longer clerking for him, but thinking about jobs that I might want to take or positions that have been offered to me. Talking about, frankly, political positions that were being taken by people. It's sort of hard. I don't have a great example of this, but you just got the sense when you were around him that he cared very deeply about intellectual rigor and principle and objectivity. And if you said something, this is my experience at least, that he thought was sort of political, but not well through and not principled, he would let you know. And he liked to point those things out. So I don't know, it's very hard to give some concrete answers or other than to say that the aura that he projected to me at least was a man of great principle.
Sarah, is there anything in your experience with him as a clerk that sort of exemplifies that?
I just give two examples. One we've sort of touched on, which is the judge felt very, very strongly about not reaching out and deciding things if there was not jurisdiction. So strongly that he would offer a free lunch to any clerk who found an unbriefed jurisdictional defect. Like that is how strongly he felt. The judges should not be sort of wading into things over which they had no power. And then the second example is simply the judge was once called for jury duty in DC court, which I think he described as just a terrible, terrible experience. But afterwards, he reflected on it and realized perhaps one reason of many for his discomfort was that it was not the proper role of the judge, who might later on the DC circuit have to entertain some of these cases from the DC Superior Court. So even then, the jury duty was an opportunity to reflect on that role.
Paul, anything to add?
No.
Okay, all right.
Judge Silberman would want me to be restrained. So
So many of the students here are my students, current students, former students, or fellows of the center or Bradley scholars of the center. And many of them are going to be going off to clerk and be leaders in practice and eventually judges themselves. So Sarah, let's start with you. What advice would you give them as future clerks that you learned during your time as clerking for Judge Silberman?
We've touched on this a little, but I do think just in every conversation, whether it was about cases or jobs or how to live your life, I mean, honor was probably the most sort of important or the most important value uniting just the different contexts. So do whatever job it is and do whatever, your role as a husband or wife, like with honor, do it in a way that is straightforward, do it very honestly. I think that situations I remember him sort of having a most negative view were ones where people were leaking things to the press or were sort of writing tell-alls or doing things that just sort of seemed like a breach of oaths or duties that you had taken. And he really not a fan.
Paul?
So I guess I'd say two things. One is, I think one lesson from having been really truly blessed with the opportunity to clerk for Judge Silberman is you should pick your mentors well. Because, the three of us, Justice Barrett, we've all benefited enormously from having Judge Silberman as a mentor. And we could have clerked for somebody else. And in life, there are lots of paths and there are lots of ways to make a decision about what clerkship, what law firm, what job to take. And I think in your professional sort of career, you really shouldn't underestimate the value of having really amazing mentors and what a difference they can make in your career, especially when you have the benefit of a number of years of kind of professional practice after that. So if, you know, if you're on the kind of sort of the knife's edge between two job offers, and you really just get a better feel that one of the people that you'd be working for would be a better mentor than the other one, I would really make that your kind of, you know, tipping point decisional framework, because it makes all the difference, kind of who your mentors are. The second thing I just sort of say about Judge Silberman is part of what made him a great mentor is he was always available to his law clerks to give advice. What's maybe even more remarkable is he would give advice to essentially almost anybody who would ask. And he really was incredibly generous with his time. I mean, if you think about the arc of his career, he really had too much energy to be an Article III judge, especially an Article III judge the way he wanted to be an Article III judge, which is restrained and limited by the arguments of the party. He had all this energy. And so one of his outlets for that was to be a great mentor, and to be a great mentor for his law clerks, but also for stray cats and dogs that, you know, they would be like a friend of somebody who clerked for him, who the law clerk would say, you should really ask Judge Silberman about that. And he would take somebody he'd never met before out to lunch, and oftentimes would develop a lifelong relationship out of that kind of relationship that just was really something. He didn't need to do that, but he was really had a gift for being a mentor. But the one thing, and this just echoes what everyone was saying about his honor and his principle, he was a great mentor, but you could never call him for advice if you didn't want to do the right thing.
I have a little tip on mentors, and that is, if you've had a mentor like that, you should go out of your way to thank them for being your mentor while you still have the chance, because there may come a time when you no longer have the chance, and then you'll regret that you didn't say the word for your own sake as well as for your mentor's sake. Judge Nichols, you're on the other side now. You hire clerks and you have to be served by clerks. Is there anything, any advice you have for our students along those lines, or the practices that Judge Silberman engaged in that you have emulated in your relationship with your clerks?
Yes, I have three thoughts. They're not, some of them are my own to some extent and not necessarily things I learned from Judge Silberman. The first is just about clerking generally. Do it if you're really committed to it, but don't do it just to check the box. It's a great experience. And one thing that we haven't really talked about, but is if you think about any clerkship, and it was true for us, we got to work directly for an entire year with someone who had been deputy attorney general, et cetera, et cetera, et cetera. At a law firm, you go in as a second year associate and there's some senior partner who's many levels between you and he or she and him or her, but you get a year to work with one of the best lawyers in the world. It's really a remarkable thing, but you need to be committed to it. You don't want to go into it not certain. That's one piece of advice. Second piece of advice, and this is something I learned as a litigant. It's certain, I mean, when I was litigating, certainly something I learned when I was interviewing with Judge Silberman for clerkship. You can never be over-prepared. This is a general piece of advice, but when I was standing up, and I'd be curious to see whether the practicing lawyers here agree, it was always an incredibly uncomfortable feeling to not be fully prepared, worried about the question you're going to get. It's a little bit how I felt when I did my interview with Judge Silberman for a clerkship. First clerk interview I'd ever had, and was I prepared enough? On the other hand, if you go into an argument or a situation over-prepared, for me at least, it means I have a comfort level. I can speak. I'm not worried about what the next question is. So whether it's a job interview with a judge for a clerkship, or standing up in front of the Supreme Court, which I've never done, but in a court of appeals or a district court, my view is I never felt that I had made the wrong decision by preparing more. And then people have already said this essentially, but and Judge Silberman, I think, very much valued this. It's a version of honor but it's a little bit different. It's about being true to who you are. I think that's honorable, of course, and principled, but my two co-clerks my year were Democrats. And he loved that they sparred with him, stuck to their guns over cases and politics. He valued that. And I think it was terrific for them to do. I stuck to a different set of guns. And I try to do that still today. And I think Judge Silberman would say to everyone sitting here, be honorable, be principled, but stick to what is true to you, which sounds cliched, but I think it's important.
Well, my last question before we have an opportunity for one or two questions from the students and others who are here. We put this together on relatively short notice. This was a big surprise that this happened. And we called each one of you to participate in a program on a Thursday night. You all three are really, really busy people. And yet all of you, each of you just unhesitatingly agreed to do this without any hesitation. So I just want to give each one of you the opportunity to make any additional remarks you have about, why, what Judge Silberman meant to you personally. Justice Barrett's had a chance to say that. I've had a chance to say that. I want to give each one of you a chance to say that as well. Sarah, maybe we'll start with you.
I'll start with a story because I actually met my husband at a Silberman clerk reunion. The odds, I guess, were in our favor because I think we're the only single people there. I was an anticipatory clerk and my husband was a previous clerk because I clerked at a time when the judge only had one clerk per year. So we started dating. I showed up at chambers the first day and the judge, starts getting to know me and says, is there anything I should know? And I said, well, I'm dating one of your former law clerks. And he took great interest in this because despite being on the bench for many, many years at that point, none of his clerks had married each other. And so every Monday when I came into chambers, the judge would ask, has Jeff proposed yet? And I would say, no, Judge, we've been dating for 2 months. And the judge would say, is there something wrong? Stop wasting daylight. So my husband proposed after 5 months, which most other people thought was very fast. And the judge picked up the phone and called my husband and said, what took you so long? He then performed our wedding for us. And every year since then took a very keen interest in whether we would be producing grand clerks and we eventually did. And we just had our third baby, our first boy, and named him, his middle name is Laurence for the judge. Larry Harris was a little too much to settle a little boy. But it's sort of one of the happiest things for us was that the judge knew that and knew how much we loved him. And he was not just a great judge, but just sort of a great person in all respects.
Paul?
So there are those of us who are going to call your son Larry. We're just not going to take no for an answer. So I don't know what else to add other than, you said we all sort of came on a Thursday night. We would have come Thursday at midnight. We would have, if we had to, crawl over glass to get here, we would have done it. And because that's the kind of loyalty that he inspired in his clerks, because it's the kind of loyalty he showed to his clerks. And it's the kind of personal character that he demonstrated every day. And, I was calling him for advice until the very end. And like I said, you never called him unless you wanted to do the right thing and you wanted his good counsel, but he would give it to you no matter where he was. He was literally over in England when he should have been having, a glass of wine with Trisha. And instead, he took a call from me and gave me some great advice. And then in classic Judge Silberman fashion, he told me, I really have to go do this thing over in England on this tour. And he hung up and 5 minutes later, the phone rings. He said, one more thing. Couldn't let it go. He still had one more good piece of advice to give. And, the wine can wait. So thank you, Trisha. Thank you for your patience. But that's the kind of loyalty he showed, I think, to every one of his clerks and even others as well.
Judge Nichols?
I would just say, I'd say two things. One is general, which is like Justice Barrett, I love Judge Silberman. That first year out of law school, working again, 3 clerks with this lion was foundational and incredibly important in my life. So that, and it, as Paul was just saying, it carried on throughout my career. The other thing that hasn't been mentioned is he had an incredible sense of humor, and he loved to give and receive a hard time. As you know, we had so much fun in chambers. We had so much fun whenever we saw each other. He loved to poke, and he loved to be poked back at. He just had a really terrific sense of humor, and I know that's not about his influence on the law, but I thought it needed to be said. He was a delight to be around.
Great. I think we have time for maybe 1 or 2 questions. And, yeah, John. Okay, could each person identify themselves?
Like being a lion who's allergic to zebra. He's got.
John, you want to take the mic?
Yeah.
Oh, okay.
So,
Okay.
all right. And then he does Heller. And in my experience, the longer you're in the government, the more hostile you are to Second Amendment rights. We just always had that feeling. And I'm wondering, is that because of just intellectual rigor, or is there a little bit of wanting to be against the contrarian?
Anyone want to take that one?
Well, let me just, I will say this. I don't think Judge Silberman was contrarian to be contrarian, for contrarian's sake. He might have looked like a contrarian at times because he was not always willing to just settle for conventional wisdom. And in my view, in Heller, he was confronted. He had a plaintiff who had standing, others didn't, and he was confronted with this question, and he believed that the other courts of appeals had gotten it wrong. And so what may have seemed contrarian to some was, in my view, his having looked really hard at a question and decided, I think that other people have just not gotten it right. I mean, that's not to say he didn't love to play devil's advocate or to push hard interpersonally in a discussion. He loved the give and take, not just of jokes, but of substance. But I don't think that made him a contrarian. That just made him intellectually interested, and he wanted to probe arguments.
Yeah, I don't think he was a contrarian. I just think he was a principled man in Washington, D.C. And that looks contrarian to the naked eye. But honestly, like, I mean, you actually hit the nail on the head in the sense that, there are certain tendencies that he would recognize, like people who are in the government service for a long time, they see their libertarian streak shrink, or they don't have an appreciation for certain kind of counter-majoritarian rights in the Constitution, or a tendency that he spoke out on early in his career, long even before I clerked for him, was, the tendency of people at the State Department to not like the United States of America. All of those things, like he kind of saw the tendency, the drift, the capture, and he understood that the way you resist that is not to be a contrarian, but to be very principled and to understand what principles you're applying, which means that, whether that means you just apply the text of the Second Amendment, or if that means that you're still serving the president of the United States when you work at the State Department, all of those things really, I think, came from kind of those principles.
Yeah, I think he didn't just sort of zig just for the sake of zigging when others were zagging. I think he was persuadable, and he was persuadable by logic. And I think the biggest sort of fights in which he might have looked contrarian on legal issues were things that, like, no, if you were truly a contrarian, you probably wouldn't have picked, like, for instance, whether you would vacate when you remanded to the agency under certain circumstances or not, which provoked, like, and I think continues to provoke, like, much consternation on the DC circuit. He just, I think, wanted to get it right, and that's it.
I think we have time for one more question. There is one. Here.
Hi, my name is Brittany. I'm a 2L here at Georgetown. And my question for you guys is for those of us who still have a few semesters left before we graduate, what, if anything, you would recommend us getting involved in or trying to extern in since we're here in DC to really set us up to be the best lawyers we can when we graduate?
Sarah,
Oh, gee.
you want to go last?
I guess I'm happy to give general advice, but I think be interested in things other than law school, honestly. I think that is one of the judge's best traits. Like, it was just fun to be interrogated by him on like current events. I mean, at least if I had read the newspaper that day, if I had not, it was like, that's fun. So take advantage of being in DC, but take advantage of also being around people who have outside interest and figure out what those are.
So do you mean besides taking my separation of powers seminar next year? Okay. Besides that, I mean, look, this is such an awesome law school, in part because of the professors and the administration, but it's mostly an incomparable law school because of where it sits. And so, I mean, I don't know, how many times you've walked over to the DC circuit. I think they're now letting people back in. You walk over to the DC circuit, watch arguments, see people do arguments well, and see people do arguments poorly, and figure out what's the difference and learn from it. You might have to stand out in line, but go to the Supreme Court and watch arguments there. And the same thing. And I mean, I think one of the incomparable parts of the clerkship was just the ability to watch all these arguments in the DC circuit and then have sort of a kind of a critic's guide to what worked, what didn't, what was the right approach, what would have been the better answer. That was like that's another kind of encapsulation of Judge Silberman. Like, he would never answer the questions for the counsel. He wouldn't, he knew what the role of the judge was, but that didn't stop him from afterwards in chambers saying, what the answer should have been? Here's what the answer should have been. But you only have to walk a couple of blocks each direction and you can just see some great arguments and some terrible arguments. And they're both incredibly instructive.
I agree with everything my co-panelists have said. I, in fact, try to do that because of my experience with Judge Silberman. Whenever we have an argument, I come back to chambers and basically debrief with the clerks, talk about who did well, who didn't, et cetera. The thing I would add is I would seriously consider doing something at DOJ. You're here, you have the opportunity, DOJ. The executive branch generally is obviously very important. It's here, but I think DOJ is an incredibly interesting organization and institution. And for a lawyer, I mean, it is the most important, other than the White House counsel's office, it's the most important place, I think, that a lawyer can work in the city and the government. And I don't have to concede that. I don't know. It depends who you ask, I suppose.
If you ask a former Solicitor General, they're going to say you don't have to concede.
I know. But seriously, I was at DOJ for 4 years. It was an incredible experience, and the opportunity to do something in whatever division of DOJ as an internship or externship or whatever, I would seriously consider that, because that's the kind of opportunity that you would get here, but not other places.
Well, to conclude the evening, I want to thank the panel for the time that they took to give these thoughtful remarks. I really want to thank Justice Barrett for coming here and for her very touching recollections and memories of Larry. This group who are speaking to you is a wonderful testament to Judge Larry Silberman and his legacy. And Georgetown Law is honored to have had him as a visiting professor, not an adjunct, but a visiting professor for so many years. He will be deeply missed, but without a doubt, his legacy will continue through the people that he touched. Before we break for the reception, I'd like to pause for a moment of silence for Judge Silberman and for those many loved ones, his loved ones. So join me, please. Thank you. And I want to now take the opportunity to thank our panelists and thank Justice Barrett for their remarks.
I agree with you. I couldn't not say that.
There's a reception. Where's the reception? In the next room. There is a reception. Please join us for a reception.
No, actually. Affirmative each other. Thank you. Pleasure. Nice to see you. That was great. You bet. That was fun.